Welcome to the Contract Law Overview, which you can use for revising for your Law of Contract exam. This is a downloadable PDF file, which you can also bring in as part of your notes. Make a lot of annotations on it so that it will help you to look through your other materials. This is meant to be used as a guide to an overview of all the notes that you have. So to give you a big picture view of what you have so that you can refer to it quickly during the open book exam. So let's start off with the first question. Is there a valid contract? And when you look at this, you will see that basically there are four things that give us a valid contract. You must have offer, acceptance, consideration, and intention in order to have a valid contract. This is the first kind of question that you are going to face in any contract law exam. So let's zoom in on this. The first thing we look at is offer. And there are two questions that always come out in offer. One, is there an offer at all? Because sometimes what is being stated is not even an offer. It might be an advertisement. Remember, advertisements are not offers. Advertisements are invitations to treat. It could also be a request for information. So when you're asking for information, it's also not an offer. So if there's no offer, then clearly you don't even begin to start to discuss, is there a contract or not? There's no contract. Sometimes an offer is given, but it's terminated. And it can be terminated by revocation, meaning you pull it back. But remember, you must pull it back before it has been accepted. If you pull it back or revoke it before it's accepted, then the offer is terminated. The other way is it could be rejected by the offeree. If the offeree has rejected it, and that includes a counter offer, then the offer is also terminated. Remember, a counter offer is same as rejection of an offer. And the last one is a lapse of time. Sometimes when the offer has carried on for too long, there's past a reasonable amount of time or a time which is specified, then the offer can also be terminated. In both these cases, all these cases, if the offer is terminated, then of course you don't need to carry on because there is no contract. Let's look at the second factor, acceptance. Acceptance must be communicated. So if it's not communicated correctly to the offerer, then that's a failed acceptance, and therefore you also have no contract. Or it could be by the wrong method. Maybe the offerer wanted it to be in a particular way, and so if you accept in the wrong way, it will also be a failed acceptance. And the last one is silence. Remember, even though laymen say that silence is consent, there's no such thing in contract law. The silence can never be acceptance of a contract. So if there's no acceptance, also you don't need to carry on, there is no contract. As for consideration, remember, consideration is the value that is given from both sides. Remember that both parties need to give consideration and it cannot be passed. So you look into the notes. Like I said, this is meant to be an overview, some of the key areas. Do not limit yourself to studying only this particular overview. Make sure that you also look at all of the notes and slides, but this is meant to give you a big picture. So for consideration, remember, consideration cannot be passed. So you cannot have a consideration for something which has already taken place before. And also the consideration it can even be a small amount. It could be adequate. The fourth element is intention, and you need to have an intention, all of these four, in order to have a valid contract. Now, if there's no intention, then there will be no contract formed. How do we know there's no intention? Typically, it is in a social setting, that means among friends, then there will be no intention to form a contract. Or it could be a domestic setting among family members, then there will also be a presumption that there's no intention to form a contract. Now, this does not mean that you can never have a contract between friends or family members, because it's only a presumption. So this is just the starting point. But the opposite side is that if it's not social, it's not domestic, it's more a commercial situation. If you are buying things from a shop or you're dealing with people in terms of business, then there will be a presumption that there is an intention to form a contract. So pulling back out again, you will see that when you have these This is what is going to give you your valid contract. And this is the first question that you'll be asked in contract law. And when you look at this, you'll be able to examine if it's missing any of these: offer or acceptance or consideration or intention, then you will not have a valid contract. Next up, we will look at whether the contract, which has already been valid, can then be declared void. So this will carry on in the next video.